Okay, let's get going. Thank you for joining us today. I'm Kimball Parker. I'm the CEO of SixFifty. For those of you who are hearing about SixFifty for the first time, we work with the law firm Wilson Sonsini to automate the legal documents that a lawyer would typically write for you. So instead of paying a lawyer $50K, let's say, to write the policies, contracts, and other paperwork that you would need for the CCPA or the CPRA, and then getting it a month later, we can do that for you at a fraction of the cost and in the same day. And so it's all backed by one of the best law firms in the world. And so our service is like TurboTax for complicated legal documents. So that's just a little bit about SixFifty. Today, we're going to be talking about the CCPA and the CPRA. And a lot has happened in privacy recently. China passed a new privacy law that's similar to the CCPA, similar to the GDPR, that goes into effect at the end of the month. The CCPA is kind of transferring over and incorporating all that CPRA into it. We have Colorado, Virginia, our new privacy laws are coming online. So a lot is happening, a lot is in flux. And so today you're going to hear from some of the best privacy experts in the nation about this CCPA, CPRA situation. The first is Marie Colbeth. Marie graduated near the top of her class from one of the best law schools in the nation. She then clerked on the Fifth Circuit Court of Appeals, which is right under is one of the courts that's under the Supreme Court. She then taught at BYU Law School, worked for a firm in between then, but then ended up at BYU Law School, which is where we poached her away from. BYU has still not forgiven us, but Marie, it's not a stretch to say, is one of the best privacy experts in the nation. And so some great knowledge coming out of Marie today. The other person is Austin Smith, just like Marie, graduated near the top of his class from one of the best law schools in the nation, the University of Virginia. Austin also clerked on the federal court and has worked for some of the most important law firms, privacy law firms in the nation. So started his career with Hogan Lovells, worked at Davis Wright Tremaine, and we were able to snatch him away for us. And so we're very excited to have Marie and Austin here. Marie and Austin are the people who build our automated privacy products. So a really deep knowledge of what these laws entail. And their presentations are usually pretty dense. So be prepared for some really dense information about privacy. They're also fun. So they do a really good job. A few final things before we dig in. We have automated the policies that companies need for a bunch of these laws, for China, for California. We're working and going to release later this year or early next year, Colorado and Virginia. We have the GDPR, and we're going to have the UK variant of the GDPR soon. All of those offerings you can find at SixFifty.com. And then you can click on privacy to see our privacy offerings. And so SixFifty.com is where you can go and learn more and schedule a demo if you want some of those automated tools. Second, put your questions into the Q&A and not the chat. It's a little easier for us to manage the Q&A, and then we'll kind of gather that, and sometimes we'll publish it out. It's a little harder for us to do that on the chat. So if you could put your questions into the Q&A. So with that, I'm going to turn the time over to what we call the dynamic duo of privacy, Marie Colbeth and Austin Smith. Take it away.
Thanks, Kimball. Happy to know that you think of it as being a dense presentation in the good way, not the bad way. So I'm just going to walk you through what we're going to be talking about today, just really quickly so you know what to expect. We're going to start by talking about CCPA enforcement actions. I know a lot of our customers who are on the call, as well as others who are kind of learning about the CCPA for the first time, are really interested to see what's been happening on that front coming out of the Attorney General's office, and as we get ready to move to a new agency that's going to oversee enforcement So Austin will start us off by talking about that. And then we'll shift to talk about the CPRA, which is the new, stronger, amended version of California's privacy law that will be going into effect in 2023 for the most part, but some of which is already going into effect. And inside of that, we're going to talk specifically about cybersecurity audits and risk assessments, automated decision-making, consumers' rights, which have been expanded under the CPRA, and also responding to requests to know. When we talk about those things, we're going to be talking about the rulemaking process that's about to happen to expand upon the requirements of the CPRA. So we're going to spend a lot of time talking about what we are going to be expecting to see in the next little while and how that rulemaking process works. So with that overview, I will hand the time over to Austin to get us started on enforcement actions.
Great, thanks, Marie. So as Marie mentioned, a lot of people who have to comply with the CCPA are very curious about how it's actually being enforced in the real world, where the rubber meets the road. So the basic background is it's enforced by the Attorney General, not by individual consumers. And the Attorney General, if they see what they think is noncompliance with the CCPA, they will send a notice of the alleged violation to a company. And then businesses have 30 days to cure or show we're actually already in compliance. In just this last July, the Office of the Attorney General released 27 examples that are kind of de-identified, but give some detail into specific cases and how they've worked and what's happened. They also mentioned that 75% of businesses at that time had already complied with the notices that the Attorney General had sent out within 30 days of receiving them. And the other 25%, many of them, they said, were still in that 30-day window. So businesses have apparently been pretty successful at complying with what the Attorney General has asked about. And virtually every aspect of the CCPA has been something that the Attorney General has looked at and told companies they need to do better at. Privacy notices, do not sell links, to request methods, both of which have to be working, it turns out, contracts, all of that. And we'll go through a few of the examples here. The last thing to note there with what the Attorney General has put out is a tool that allows consumers to notify businesses that don't have one of those do not sell my personal information links. So if you sell personal information, which under the CCPA is a very broad definition, you need to have one of those links on your homepage. And if a consumer doesn't see one, this tool allows consumers to kind of generate a letter they can send to you asking about it. And it will also let the Attorney General know you've sent this letter. So that's something to keep an eye out on. But for specific enforcement actions, we've picked 4 that I think are representative for especially what our customers are looking at and asking questions about, and that kind of cover the gamut of the most often violated or allegedly violated provisions. So I'm not going to read this whole text. We will send the slides out later, and the Office of the Attorney General in California has the full 27 examples on their website, but this is an example of what they provide. So this is a company that collects personal information and sends emails on its customers' behalf, a classic vendor/service provider relationship. And the Attorney General noticed that they weren't giving notice to consumers or allow for requests for consumer rights. And they notified this company, and the company was able to respond, hey, we're just a service provider. And they were able to show that their contracts were in place and everything was set up right. And they added some clarifying language to their terms of service. But they were able to say, hey, we have everything in order, actually. We're not using the one customer's information for another's, that type of thing. We are acting as a service provider. And so the Attorney General was satisfied with that. The next example here is about updating privacy policies. It was a video game distribution company, and we have a picture of the Amiga CD32, which desperately needs updating, just like this privacy policy did. And this was just sounded like all around very non-compliant privacy policy, didn't have list the rights consumers have or give categories, didn't say whether it sells personal information, all of that, and even gave incorrect instructions for how consumers could exercise their rights. So after this company was notified by the Attorney General, they updated their privacy policy to fix all of these issues. And this just goes to show that just having a privacy policy that checks all the boxes accurately is very important, and definitely something that the AG is looking at. A lot of these enforcement examples related to privacy policies. The next one here is about the sale of personal information, and an issue that I know a lot of our customers and just a lot of companies that are subject to the CCPA have questions about, which is having third-party online trackers on its website. And in this situation, this retailer shared data with advertisers about consumers' online shopping, and they didn't have a service provider relationship with those companies. And so the Attorney General's position was that this was a sale, and you need to have opt-out rights and recognize those potentially even from a browser extension, and handle all of that. So what this retailer ended up doing was that it added opt-out rights from sales and stopped sharing personal information with third parties under conditions that amounted to a sale. So that's definitely an issue that ends up being somewhat fact dependent, but is definitely something you need to be looking at, is what type of information about your customers are you sharing with third-party advertisers and others. So that one's worth digging in on potentially. The last example that we wanted to go through is a mobile app game situation. And even if you don't have a mobile app or if you don't sell games, I think this is interesting because this was a company that had software from a third-party mobile advertising platform within its app, and that ended up sharing a lot of personal information with the third-party advertising company. And it sounded like the mobile app game store didn't really know exactly what this third-party software they'd included in their app did. And it ended up also including minors aged 13 to 15 in the group of people whose personal information was being shared. And if you know much about the CCPA, you'll know that that is definitely something that the CCPA is concerned about. So in general, this company needed to provide an opt-out mechanism for adults whose information was being shared, or an opt-in, and an opt-in for any minors between 13 and 16. And they were notified of this alleged noncompliance, and they ended up removing the ad software, and also made sure that they were handling minors' information better as well. So things like age gating, making sure, asking that they're above a certain age, and also requiring parental verification in certain situations. So children's information is definitely something that you want to be very careful about how you're handling and whether you're handling. And of course, outside the CCPA, COPPA, the Children's Online Privacy Protection Act, is at the federal level and has a lot of requirements for personal information of children under 13. So a lot to consider there. You definitely want to make sure you're handling children's information correctly, and whatever software you're using, if you're incorporating someone else's software or plugins or whatever on your app, on your website, you should make sure you know what they're getting out of that, that you have appropriate terms in place, perhaps contractually, or you're allowing people to opt out if the information that you're giving through that software ends up being a sale under the CCPA. So those are the examples of existing CCPA enforcement actions. We wanted now to pivot, as Marie mentioned at the beginning, to the CPRA. And I apologize on behalf of California for all of the acronyms that are one letter apart. It's really not great. So the CPRA, the California Privacy Rights Act, was passed in November 2020. And it amends and strengthens the CCPA. We'll go into some detail about that and what's happening on the regulation front. But most of that law goes into effect beginning of January 2023. And also the law creates a new California Privacy Protection Agency, or CPPA. Again, these acronyms are not ideal, but that will be an entire agency dedicated to enforcing the CPRA. So things like these notices that the Attorney General has given, that's one of many things the Attorney General handles. This new privacy agency will be focused only on that. So we can probably expect even more enforcement and more interest in how that works. Just recently, this last week, Ashkan Soltani was appointed the executive director. He actually helped craft both the CCPA and CPRA. He's a big privacy rights advocate. So he'll help oversee rulemaking and how the CPRA gets molded in that way going forward. So a brief summary of the rulemaking process. Again, sorry, this is a little bit dense, but wanted to give you some details on the background. The privacy agency just put out a request for public comments on a variety of topics that it is required or might issue regulations on. Those comments are due November 8th if you're interested in submitting anything. These are not comments on like draft regulations. We don't have any draft regulations yet. This is just the agency saying, hey, we have to craft regulations on all these topics. Does anyone have any thoughts on, how we should define this, what in practice we should require for this, that type of thing. And then the formal rulemaking, where they actually draft the rules and have those for public comment and things, will come after that. They're also planning on holding informational meetings where they describe what they're doing, what they're required to do, and get some feedback from consumers, private businesses, that kind of thing. And the deadline for the final regulations is July 1st, 2022. So just about 8 months from now. So hopefully they'll be ready by then-ish. And now we're going to talk a little bit about what we're seeing in that rulemaking, what we will see, and Marie's going to start with cybersecurity audits and risk assessments.
Awesome. Actually, before I do that, I thought I would ask a question to see where people are at with the CPRA. So if we could get our hosts to help us pop up those questions. We're really interested to know, and you can mark more than one answer on this question, how ready companies are for the CPRA. So in terms of what you've already done, whether you've maybe read some summaries about what the CPRA is, maybe read the law itself, if you started your implementation planning process, maybe you've already implemented some changes because of the CPRA, or maybe you're like, nope, this is the first thing I've done today. I haven't done anything yet. We'd be really interested just to kind of get a feel for where everybody's at to make sure that we keep things relevant for people while we're going forward into this section on the CPRA. So we'll just give people a second to answer that. And while you're answering that, I'll also kind of weigh in on what Austin was just sharing. If you are a company that deals in a lot of data and you're concerned about how this is going to have an impact on your business, on your customers, and all the different stakeholders that you work with, you might want to consider participating in the rulemaking process. So when you do get these slides after the event today, you'll notice that on Austin's slide about rulemaking, there's actually a little link you can click on if you want to submit a preliminary comment. So those are due, like he said, on November 8th. So you can participate. Maybe you'll take away some information today that makes you want to participate. Maybe there's other things you've been focused on. This is a good time to do that, to be involved in that way. So why don't we take a look at those poll results? Okay, so it looks like 49%, so pretty much half of everybody has at least read some summaries. Followed next, we've got people who have started some implementation planning. That's fantastic, 34%. And then this is not surprising to me at all because the law has not gone into effect yet, and we're still at the very front end of preliminary rulemaking, 23% who haven't gotten started yet. So for that 17% of you that have started actually implementing your changes, awesome. As a privacy Policymaker, I get really excited about that. When people are ahead of the ball, it'll make things a lot easier for your teams. But there's still time for early implementation for everybody on the call today, no matter what you've done. So this is really helpful. We'll try to keep that in mind as we go through the rest of the presentation today. Okay, so first step with the rulemaking process, the first, it's not a proposal yet, it's a proposed area where there will be a rule coming. So if you want to make a comment on it, you can. They're asking us to comment on these issues. The first one is regarding cybersecurity audits and risk assessments. So with this, the reason that it's being put into the preliminary rulemaking is that the CPPA, the new agency, was instructed to issue regulations that require businesses who process whose processing of consumer information presents high risk, significant risk to consumers' privacy or security. This new agency is required to issue regulations to those businesses, requiring them to perform at least annual cybersecurity audits and to submit regular risk assessments regarding their processing of personal information. So if your business is engaging in any sort of personal information processing that might be considered high risk or significant risk, you are going to have to start going through some type of audit process starting in 2023. And this rulemaking process is going to determine what that will look like, in terms of what's required in the audit. So this is, the kind of overarching requirement that we have regarding risk. And that's sort of what the weird picture is about. It's risk. It's to make you think of something risky. But with that, the question then becomes, we'll talk about the cybersecurity audits first. The question becomes, when does a business's processing pose that significant risk? What is included in significant risk? Can we advance the slide by one, please? Thanks. So figuring out, the agency will issue a rule that tells us what qualifies as significant risk, and also what should be included in the audit requirements themselves. So what will the audits cover? What processes have to be followed to ensure that they're significantly independent and thorough. And we don't have a lot of information around these yet because we're at the front end of rulemaking. But for those who are familiar with Europe's privacy regulation, the General Data Privacy Regulation from Europe, the GDPR, which I just slaughtered its acronym, you might recognize this as being somewhat familiar language. So I thought I'd just talk a little bit about what we see there, which might, give you an idea for something you want to submit to California in terms of a comment. So in Europe, the way that they've defined this, they call it high risk, not significant risk. But they talk about it being when the processing is something where you see this potential for severe harm to individuals. It's a higher threshold than just risk. Any data processing has some risk involved in it, right? But if harm becomes more likely, or the potential harm is more severe, or there's some combination of the two, then you're looking at more significant risk. Things that qualify as high risk in Europe include things like the use of innovative technologies or the novel application of existing technologies. So think about things like AI. They require a risk assessment in those situations. Or if the processing you're doing could involve a denial of service, where your decision-making based on this processing that you're doing might deny somebody a benefit, like access to housing or access to a job. So maybe you're doing background checks. Large-scale profiling, so if you're just processing like a really high amount of data, could in itself, the fact that there's so much of it, be inherently risky. Sensitive information, so if you're looking at biometric data, genetic data, if you're data matching, where you're pulling in data from different sources, and you're essentially creating new, much more robust data sets that might also include things like inferences about individuals. And then any processing that you're doing that might be invisible to the individual, so they don't realize what's happening if you don't give them notice, if you're doing some sort of tracking, particularly very specific geolocational tracking is considered high risk. And then anything that targets children or other vulnerable individuals, those are all considered high risk in Europe. And so as we see rulemaking around this coming out of California, we'll probably see similar types of categories going into the regulation to define what is high risk. So that's something to think about, to maybe comment on if you're engaging in that type of processing and you have thoughts about, the best way to assess how risky it is. And, because at the end of the day, if it's too risky, there's the chance that you'll be told you can't engage in that processing activity. And that is, of course, what no business wants to be told. So we need to find ways to make the regulations work so that it's safe for people, but it allows businesses to go forward with their work. So with that, we'll talk a little bit about the risk assessments themselves. So things that will have to come out in the regulation are, who's got to submit one, what will be included. And keep in mind, this risk assessment is different from the audit. This is determining what level of risk is happening, and how often they're going to be done. So the audits, it says in the law that they have to be done at least annually. The risk assessments, it doesn't say, but the regulation will tell us. And then it will talk about, the balancing act that we have to engage in. So when is the risk to the consumers higher than the benefits to the businesses? And in those situations, when should the processing be restricted or even prohibited because of that risk? And again, I'll just use Europe as an example. They have some key elements that they look at when engaging in the impact assessment process. So they have to look at the processing, describe it. They have to look at, the necessity of the information that they're asking for and processing, and the proportionality of what they're getting compared to the purpose for which they're getting it, and use that to identify and assess the risks. So you have to think about, okay, not only what information am I processing, but how likely it is to be a target, maybe of bad actors, right? So the higher risk there for higher value information that's maybe more sensitive, those kinds of things. And then you have to identify measures that you can take to mitigate the risk. And that is something that isn't really touched in the California law, but if it goes into the regulation, it might enable companies that are engaging in high risk activities to still go forward with those activities as long as they do some of these risk mitigation efforts. So that's something that I think we'll see coming out of this rulemaking process that, again, would probably be reflective of what we see coming out of Europe. If you're already engaging in this process there, you might be a little bit more familiar with that. Okay, and then so kind of the last item on the risk assessment and audit piece is that in addition to internal assessment that you do for your own company and audits that you do where you would have an outside auditor come and check what your company's actually doing, the new agency, the CPPA, also has the right to perform investigative audits. So like Austin was mentioning before, where consumers can submit something to you saying, I think that you're violating the California law. I'm going to stop using the acronyms. I think you're in violation. And I'm also copying the Attorney General on this. If they want to investigate, the agency has that right. They can do audits. There's going to have to be rulemaking, though, around what the scope of that audit will include and what process they have to follow to engage in one. What criteria they use. They're not going to do an audit of every single company that gets a complaint. Obviously, that would be too much. So what criteria for selecting who gets audited? And then, interestingly, they also are looking for comments on safeguards for protecting consumer personal information against disclosure to the auditor. So thinking about, okay, when we get audited, we're opening up all the sensitive information to a new set of actors who are coming in to do the audit. We've still got to protect the information in that scenario too. We can't just automatically trust, right? And I think that's interesting because it might help move the ball forward for those companies that are trying to export data out of Europe into the US. And they're getting some pushback because the US doesn't have strong enough privacy laws. Something like this could be the kind of rule, the kind of gatekeeping rule where government intrusion into the data is limited. And so that's the kind of rule that would help us get past the bar for exporting European data into the US. So I do think that will be a really interesting piece of the law that we haven't seen in any other US privacy rule. So some room there to help us, move the ball forward in terms of being considered a compliant enough jurisdiction for European data to come in, at least in terms of what's happening in California. So that is sort of the next big thing that I think we'll see happening there. Okay, so with that, I do also just want to say we had somebody ask about when we say consumer information, whether that equals employee information. And the answer in Europe is yes. In California, it's a sort of yes. So these rules are to protect all California consumers, which does include people who are employed in California. However, employees in California have limited rights under these rules, at least until January of 2023. So they have the right to notice about what data you're collecting from them and what you're doing with it. They have the right to security in their data. So if you have a data breach of your employee data, there's a right of action there for your employees. But they don't have the other privacy rights. They don't have the right to tell you, I want you to delete my data, or I want you, to give me a report of all the data you have about me. So generally, we're talking about non-employees because that's a really big exemption in terms of what does and doesn't apply to them under the California privacy rules.
So automated decision-making is something that the CPRA references a bit, but mainly punts entirely to the new privacy agency to issue regulations about. The unfortunate thing is that the term is not defined in the law. The closest it comes is defining profiling, which it says is an example of automated decision-making. And the full definition is there. The key part is that last half. Profiling's any analysis or prediction about a person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. So if you're using an algorithm to try to predict or categorize those types of things for people, it's likely profiling and thus automated decision-making. Automated decision-making in other related laws generally includes anything that's AI, artificial intelligence type things as well, even if it doesn't quite fit the definition of profiling. So that is very likely that what we will end up seeing potentially from the privacy agency when they issue their regulations. And one last thing to note is that in Virginia and Colorado, which Kimball mentioned, recently passed their own privacy laws. They also regulate automated decision-making, but before any opt-out rights are triggered, for example, from automated decision-making in those jurisdictions, you have to first determine whether the automated decision-making has significant effects. So those laws say things like, if this is going to deny someone housing or a loan or, things like that that are very significant or have kind of legal effects, that's when consumers can opt out of that type of decision-making. The CPRA doesn't have that limitation. The regulations could, but as of now, it's potentially very broad and could allow people to opt out of or request access to a large number of automated decision-making processes. So that's something to keep an eye on for that. Here we have a quick aside about potential hypothetical deep AI hire candidate evaluation algorithm. A lot of companies I know are starting to use, video interviewing and even have AI programs kind of categorize and determine who's doing well, what body language they're doing and such. This one weights different things like educational background, past experience, recommendations, interview performance, and then thousands of times more important to this algorithm is enthusiasm for developing and expanding the use of this very algorithm. So that kind of raises some concerns for people. A little bit of humorous take, but that is definitely something that is profiling and would be something that the CPRA is probably going to be covering. So a little bit more about what the CPRA tells the privacy agency that they need to do regarding automated decision-making. Like I said, most of it is punted to the agency itself, but the law does say that there has to be a right to access and opt out, at least in certain situations. The access involves providing meaningful information about the logic involved in the automated decision making. So in that last example, you'd have to say, yeah, we weight your, how you do in the interview, your past experience and that, and also how excited you are about this algorithm itself. So you need to give some kind of overview of how this automated decision-making process works, and also a description of the likely outcome of the process with respect to the consumer. And that, I think, is much more of a question mark. The outcome for any particular consumer could depend on a lot of things, in addition to who they are right now. Could depend on what they do on your website, or what things they buy, or information you've received from another company, all kinds of things. So that will definitely be something that we'll want to see what the CPPA, the privacy agency, does with that. The request for comments that Marie has mentioned that are due November 8th, if you're interested in participating, the privacy agency asks for comments on things like, what should the definition of automated decision-making be, since, as noted, the law doesn't define it, how that right of access should work, when is it triggered, how do you need to provide this information, and what exactly do you need to provide, and then how an opt-out right would work. What type of information do you have to give people, telling them about the opt-out right? How do they exercise that right? That kind of thing. So those are things that the privacy agency is specifically looking at, and I'm sure this will be something that we'll get a lot more information about when those regulations come out, because the law itself is quite broad.
You have to love when they tell you, we're regulating this, but we're not telling you what this is.
Surprise.
So it's regulated by the law, but the law doesn't really tell you what it is. It's kind of a perfect, a perfect type of discussion if you want to complain about the way that rulemaking gets done. Some of the things that also have to get fleshed out during this comment period, in addition to the automated decision-making issues, are around consumers' rights. And like we said before, this generally means all Californians, but these rights are the ones where it's speaking not really about your employees. So they do have that right to notice that's listed first on this slide, but these other things are things that are regarding general consumers, not your employees or your contractors. And the ones in red are where we have differences in the CPRA than in what you might be used to from the CCPA, the original California privacy law. So we're going to focus on those. The first is the right to request correction of the data. So if you have a consumer's data, they think you have it incorrect, they have the right now to request that that data get corrected. And in the request for comments, they're looking to make rules around how to require companies to receive these requests. So if you've already been complying with the CCPA, you know that there's rules about, okay, you have to have 2 methods for people to submit these types of requests. Unless you're a company that's all online, then it's a little bit different. So there's rules around how request submission works. So they need to make those rules for correction requests. They also need to make some rules gatekeeping how often a consumer can make those requests. I'm sure many of you on the call can imagine how quickly a consumer could become a problem consumer, like the gentleman in the picture, always reaching out to you and demanding changes to things. And under what circumstances they can demand those changes. Because if a consumer is requesting information to be corrected, but your company is quite sure that the information is correct, then there's a dilemma there, right? So we have to have rules around how you make the decision about what corrections to make, and how you prevent fraud. So identity verification rules, just like we have for the rest of the CCPA. Also, the regulations are going to examine exemptions, and 2 that are allowed under the CPRA are if it's impossible for you to correct information, if it requires a disproportionate level of effort, or if, like I mentioned previously, if the information is in fact accurate. And if you claim one of those exemptions, under the CPRA, the consumer, it looks like, should have the right to submit an addendum that you would essentially attach to their data in your system if the request gets denied. So it's like, pretend for a moment, and this is an example we've seen in Europe. that you're a news organization and somebody reaches out to you and says, that story that you published about me was false. And you're like, well, we verified it across multiple sources. So you have this information is accurate response, and you can say, okay, well, it's exempt, but they may ask you to make an addendum to wherever you keep, your sources to say, this individual disputes this information. You can also imagine how that would look if, for example, you were interviewing somebody for a job and you determined that you weren't going to hire them. This is where it's nice that those people are exempt from this rule, at least until 2023. We also anticipate seeing some rulemaking around making that exemption a more lasting, permanent change for employees and contractors and job applicants. But at least until then, at least until 2023, you don't have to worry about it. But you can imagine if they don't extend that exemption, how problematic it could be if they could, an employee could dispute something in their employment file and say, no, actually I did a great job on that project. You can't put a negative comment about me in my employment file. That would be a hot mess. So we for sure will see some more rulemaking around that as well, connected to this right to request correction. Some sort of continuing exemption for employment information should definitely come out of this. Second change in terms of consumer rights is we've talked a little bit about the fact that consumers currently have the right to opt out of the selling of their personal information. With the CPRA, that's expanded to having the right to opt out of the selling or sharing of their personal information. So if you caught on to Austin's comment earlier when he was talking about enforcement actions, there have been a lot of companies that, in order to avoid the opt-out requirements, they've determined we'll just make sure that everything we're doing with data is a sharing of data, not a selling of data. And some companies were doing that very legitimately. Other companies were maybe shading the truth when in fact they were really selling data, like the one that was subject to that enforcement action Austin talked about. But now you're going to have to offer opt-outs in both of those situations. I actually thought it would be really helpful for us to do a quick poll and see, for those on the call, who's currently selling data as well as who's sharing data. So keeping in mind that with the CCPA, selling data can be more than just selling it for monetary gain. You might be giving data to a partner organization in exchange for some other benefit, and that could be treated as a sale. If you don't have essentially a vendor agreement in place with a data processing addendum that restricts the other company you're sharing with from doing anything with the data for their own purposes, you're essentially under the CCPA selling data. So we're gonna do this one really quick. So if you can just hop on and vote about whether you're currently selling personal information, yes, no, or not sure. And we don't know who's answering what, so you don't have to worry about us knowing who's submitting which answer. And then we'll switch to sharing. And if you could note whether your company is sharing data, yes, no, or if you're not sure. Okay, could we pop up those results? I know I didn't give you all very long, sorry. Okay, so for sharing, pretty close. We have 40% that are sharing data, 33% that say no, and 27% that say not sure. I can absolutely identify with the not sures because there's a lot of potential ways for data to be shared, through platform providers, right? So you're storing data through a cloud service provider. That's technically you're sharing data with them. They can't do anything with it if you've got them under a data processing agreement, but they do have access to it, right? So keeping in mind as you're learning about privacy and data and what counts as a sharing of data in the future, that would count. Okay, and then can we see the one for selling? Or should I have done it? There we go. Yeah, vast majority are not selling, and that is what I anticipated. Just keep in mind there's a lot of extra requirements right now for those who sell, if you're in that 6% that's selling data, but those requirements are going to expand to that 84% in 2023. So With the comment period, if you're in the position where you're sharing data and you want to try and keep things going as smoothly as possible, you might want to comment. The rules are, they need to identify sort of the technical specifications for what opt-out preference signals will look like. So, you know, if somebody wants to indicate their intent to opt out of the sale or the sharing of their data, you know, what that might look like in terms of like, you know, a platform, a browser plugin, or some other privacy setting that users might be selecting, for example, on, you know, on Chrome or on DuckDuckGo or on whatever other browser they might be using, for example. Also, Austin mentioned a little bit about children's data. Your technical specs for opting out signals for consumers that are between 13 and 16, they can do it for themselves, but if they're under the age of 13, it has to be their parent or guardian. And so that is a little bit different, and it requires a little bit more of companies that may be dealing in data for children of that age. So children's data is definitely more sensitive. If you can avoid collecting it, I would strongly suggest that you do. But of course, there are some businesses that can't avoid it because that is, you know, that's their target audience. So, you know, you really do need to pay attention to not just the California rules, but also COPPA, like Austin mentioned. And then also coming up in the rules with a way to allow consumers to consent after they have previously opted out of, for example, the sharing of their data. So we've got to give a way for them to exercise the right, but also to walk it back if they decide they like you so much that they want to engage with you in some way where they're sharing their data would be necessary. And so that one, I think, is a big change in terms of sharing, because that's the vast majority of companies are doing that. And then finally, in terms of new rights, the right to limit the use and disclosure of sensitive personal information. So sensitive personal information is a new CCPA category of information under the CPRA. And if this is like social security numbers, passport ID numbers, genetic information, sexual orientation or sex life information. These things all qualify as sensitive, and they're defined in the CPRA. But we do need rules around how consumers would be able to exercise their right to limit the use of that information. So again, this is really new. It's a brand new category. It is similar to what we've seen in Europe, where essentially they've required consent in essentially every situation for processing like very sensitive information. So coming up with how we'll regulate that, it's not exactly the same because it's an opt-out, not a consent in, but it's very similar if you have been operating in Europe with those consent rules. This is similar, except it's happening after the fact as opposed to ahead of time with an opt-out. And that sort of leads us into, that's the last change in consumer rights. But with existing consumer rights, there is one thing they're asking for a comment on, which is responding to requests to know. Currently, the look back period, if somebody says to you as a consumer, like, I want to know what information you have about me, you have to look back 12 months in time and give them all the information that you've collected in the last 12 months. Under the CPRA, you have to go beyond that 12 months if they ask you to. But they have this little caveat in the CPRA that says, unless providing information beyond 12 months is either impossible or would involve disproportionate effort. And so they're asking for comments about how they would figure out what is disproportionate. How do we know if something's impossible? So some rules and guidelines around sort of that exemption language. So that is one thing that they're asking for. And then just lastly, I'm not going to review these, but they're also asking for comments on a number of things that they think need to be more clearly defined in through the regulations. So we have, like personal information itself. They're asking if anybody wants to comment on how that's being defined. So if you think it's too broad, if this is the time for us to come and say, what, personal information does not include employee information. Could we go to the next slide? This would be the time to submit that comment. So personal information, sensitive personal information, maybe you don't like the new definition, you think it should be changed in terms of its parameters. So there's a lot of information, a lot of things in the current law, as well as in the version that goes into effect in 2023, that could use some more guidance that, you know, are a little unclear, maybe not that well drafted. So this is your moment. If you've been frustrated with them for the last couple of years, this is your time to comment and, you know, let the agency know what would work better from a practical perspective, because we're all here, we're in the weeds exercising and running privacy programs. And with that, we have a few key takeaways we wanted to hit on. First, of course, being that if you're going to make a comment, it's due on November 8th. And if you're just waiting for those final regs before you make a decision on something, those are coming out in July of 2022. We will, of course, keep you updated in the interim on what's coming out during the rulemaking period, because we'll know a lot before that day, because we're going to go through the formal rulemaking process. And then, you know, enforcement. Actually, Austin, do you want to touch on this one for a second? I really liked when we were talking earlier today, when you were talking about sort of the hygiene side of it. I thought that was really helpful.
Yeah, so as I mentioned, the Attorney General has been looking at every aspect of the CCPA and making sure that companies are complying. But one theme that came out was that basic privacy hygiene, as I'd call it, can go a long way in heading off enforcement actions. These are things like literally having the links to your do not sell opt-out that work, or making sure that your instructions for people to exercise their right to access are correct. Just having a privacy policy that checks all the boxes, that will obviate a lot of these enforcement actions. That, of course, is not to say that just having the right language up is all you need. You really do need to, you know, make sure that privacy policy is accurate, make sure you're substantively responding correctly to requests for access, that kind of thing. But really, the best place to start is just with the basics, the basic hygiene, making sure all of that is correct.
I would second that, and with that second step where you said, you know, like, let's get it looking right, and then let's make sure we're following it. That's also really important, because we're not just talking about, at that stage, California law, but we're talking about federal law. Because if your privacy notice is not correct, if you're telling consumers things that aren't really true about the way you deal with data, then you could be looking at a federal violation. And that's, you know, that's really different. You don't want the FCC or SEC to be coming after you for that. So that's important. Also, just in terms of what you should be preparing now, if you haven't already implemented these, you need to start looking at how to recognize universal opt-out mechanisms, you know, on your websites. If people are opting out via, you know, their browser or some other plugin or other mechanism, how do you recognize that on your end so you can make sure to honor it? Identifying any sensitive information and high-risk activities that your company is engaging in regarding personal information. And then starting a plan for how to do opt-outs for sharing. Because like I said, it's a rare company that when they really drill down and maybe do a more complete data mapping exercise, if you haven't done one of those, you find it's almost impossible to not share data. Like I almost guarantee you, even if you think you're not sharing data, you are sharing data with somebody. There's some platform provider, there's some service provider that you're sharing data with. And that's fine. You just have to make sure that you're following the rules and that you're ready to figure out how to limit the sharing. Or if somebody tried to exercise the right to, you know, opt out of sharing, if you would have to tell them that, well, then we can't provide the service to you, because, you know, that sharing is integral to the service that we're providing. So figuring those things out now so you can decide how to handle it when the requests become active, I think is a really important one. And then Austin, do you want to talk about AI actually?
Yeah, I was just going to say, as I mentioned, there are a lot of details yet to be finalized there. But one thing I would absolutely recommend is talking to, especially your tech or engineer side, about whether you're using AI or even just profiling. I feel like if you're a medium-sized company, even, it's usually only large companies that are kind of developing their own AI products. So you may not be doing that, but you know, if you're just trying to, categorize people into economic categories. This person buys a lot of things, and so we think they make over $100,000 a year, and so we're going to offer them these products or things like that. If you're using algorithms for parsing job candidates, things like that, those are things that you could be using, that your tech team might be doing, and it's not AI, so they might not. If you just ask, are you using AI, they might not think of that. But look at what profiling is defined as, and just start talking to them about that. It's not to say you can't use it, and the regulations under the CPRA won't go into effect until 2023. But I think just planting that seed in their heads that this is something the law does care about will help them understand, okay, if we're doing something here that seems a little bit aggressive, we'll talk to legal or things like that. It's absolutely worth starting to think about now yourselves and potentially with the tech side of your company.
100% agree. And that's closely connected to the idea that if you haven't done a data map or a data inventory, I would really strongly suggest it. I know companies that have sort of gotten away without doing that to comply with the CCPA. But the CPRA is a lot more intensive in a lot of ways. And so, a really good data mapping exercise can help you understand what is happening across different arms of your organization that, you may otherwise be unprepared to really comply when the CPRA comes into effect. And, like we've said, they have a new agency that's over just privacy, which means we'll certainly see more enforcement than we have seen coming out of the AG, although we have already seen AG enforcement actions happening. So with that, we're at the top of the hour. So thank you so much to everybody for joining us today. If you do want to learn about 650's products, you can go to 650.com/privacy. You can, sign up to, do a demo. You can, we have blog posts talking about a lot of these different issues. And we have a great team that would be happy to support you. So thank you for joining us today, Austin. Thank you so much for all of your information that you shared and your help. And we will see everybody at the next one of these.